I will call the Board of Adjustment meeting of October 18, 2023 to order. It is 6:35, if I'm correct, 36. Will everyone please rise for the Pledge of Allegiance? Oh, and Mr. Shields, why don't you lead us?
Sure, I was tardy, why not? Pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. May we have a roll call, please, Ms. Watson?
All right. Chair Rosaline Philippe,
Here.
Vice Chair Michael McDermott,
here.
Board Member Jeff Mondeerser,
Here.
Board Member Marlene Monestein,
Here.
and Board Member Evan Shields.
Here.
Okay, we have a quorum. With that said, we'll go ahead and make the announcements as to what the procedures will be like this evening.
Good evening, board and members who are citizens who are in attendance. This is a summary of quasi-judicial procedures. These rules apply to applications on specific parcels of land, like zoning map amendments, special exceptions, variance, and conditional use requests. The board will sit like a court, hence the term quasi-judicial, reviewing the facts presented at the hearing, applying the adopted rules as explained by staff in the staff report, and verbally. Board members can make site visits but must disclose the evidence upon which they intend to rely from that visit. Board members will disclose at the beginning of the hearings whether they have had communications with individuals on behalf of the applicant or otherwise, including who the communication was with and what the topic of the discussion was. All persons intending to speak to the board will be sworn by the clerk. Staff will make a presentation and the board may ask questions. The applicant will then make a presentation, including expert witnesses, if any, and the board may ask questions. When the public hearing is open, the public can make comments on the application limited to 2 minutes each. Citizen testimony must be fact-based, not opinion. The board may ask questions, and the applicant's attorney, if any, may ask cross-examination questions. Members of the public can decline to be cross-examined. The board then deliberates based upon the evidence presented. The board's decision must be based on competent, substantial evidence, meaning based on the record, staff presentations, expert presentations, and fact-based comments by citizens according to standards for approval set forth in the City Code. The board may then approve, deny, or continue the item. We ask each of you to treat this proceeding with respect and proper decorum, no calling out, interrupting speakers, or disrupting the proceeding. Please give this proceeding the same dignity and respect as if you were in court. Disruptions are prohibited and enforceable pursuant to the City Code. Please also silence your cell phones. Thank you. And Madam Chair, I recommend that the items be consolidated for hearing because they all involve
One person.
one property and
Right.
applicant. However, separate votes should be taken for each variance.
I agree. Thank you. All right. And with that being said, this is a quasi-judicial items that we'll be having tonight. So therefore, we need everyone who will be speaking on any items tonight to have the oath. So whether you'll be speaking for or against the item, if you're the person who the item belongs to. So everyone who will be saying anything about the items tonight, please, and raise your hand, and the oath will be.
All right, good evening. Please stand. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in these proceedings?
I do.
Thank you.
Thank you. Any amendments to the agenda?
Thank you, Madam Chair. If I may, as a point of privilege, first allow me to introduce our new zoning manager. She may have already introduced herself to the board members, but to officially state it in front of the for the board members and to the public, he have Mususi. Y'all forgive me for the pronunciation of her name. As I always say, blame it on my head, not my heart. Miss Watson.
Well,
And she-
I'm sorry, I appreciate that. It's Mawuzi, so I made you woozy, and that's why you couldn't get it together. But it's a pleasure to be here tonight. My name is Mawuzi Watson. I've been in government for 15 years, coming from Hollywood. It's just a pleasure to serve the North Miami residents, and I look forward to working with each and every one of you.
Welcome.
Thank you, Madam Chair, for that point of privilege. And the next item we would like to discuss, we had an item that was in the packet, but we failed to properly indicate it on the agenda, and that is dealing with item V823, which is for the property at 1900 South Hibiscus Drive, and it's for the dock variance. And our request to you and the board is if you would defer this to a date certain of November the 15th to be heard.
Okay. So move. Okay. Do we need to vote on it, Mr. Helm? Oh, okay, well,
Second.
Mr. McDermott made the motion, and Ms. Modestine seconded. Okay. All in favor? All right.
Thank you, ma'am. The next item is probably to vote on the minutes.
Yeah. May I have a motion to approve the July 19th minutes?
So moved. Second.
All in favor? Aye.
Aye.
All right. Communications, and I know Mr. Held would like us to take it, I guess, since we're hearing the cases together. At this time, they may disclose.
That's fine. You can do your disclosures together as well.
Okay. All right. Any communications? Anyone have anything to disclose? Were you contacted?
Yes, Jeff Bondisia. I'd like to disclose for the record that the applicant did meet with me to address any issues or concerns that I may have.
Okay.
Okay, so I've been contacted with people for and against. Yes, can you hear me? Yeah, yes, I've met with people and contacted by people for and against the project.
Same as Board Member McDermott, I've met with actually the attorney for the project and the applicant.
I also have met with the applicant and the attorney representing the project.
I have nothing to disclose, just a bunch of emails that were sent to my email, and I believe that everyone got those. Okay? Yes, no?
And
Oh, I don't know.
So just as a matter of procedure, when you receive an email like that, you just forward it to staff.
I think it came through staff.
Okay,
Yeah, because I
We was
saw a bunch of
copied.
people, yeah, on there,
okay, thank you.
so. All
So
right.
if I could, how many, did you get a count, Ms. Watson, on how many emails we received in opposition?
Yes, there were 51.
Well, we
Were
didn't
any
get all
of those
51.
emails sent to this board?
Yeah,
Yes,
I didn't receive
I
any
didn't
emails.
receive any
I
emails.
didn't receive any of them.
I received.
They were sent to,
You're also vice chair of the
the
board.
vice mayor and the mayor, excuse me, the vice chair and the chair.
Oh,
What, no other board members were included.
okay.
Okay.
So I do have a comment about the emails, which I didn't know that, I had thought the staff report said there were no written comments, but
They just came in yesterday, sir.
okay, so, my comment is, while staff previously read into the record emailed or mailed comments, we have concluded that this is improper in quasi-judicial proceedings, as the person sending the comments is not sworn, and there is no opportunity for cross-examination. So written comments submitted before the meeting are part of the record and available for review by the board.
Those individuals might be here tonight, so we'll see. All right, with that said, I guess we can move on to, I guess it's new petition, since we have no continued items. Yeah, we approved the minutes.
We approved the minutes.
Yeah.
Another
First item, well, we're taking them all, is V-09-23, variance to allow for balcony encroachments in front, side, and rear yard setback, and the address is 11950 North Bayshore Drive. And V-10-23, variance to rear yard setback to allow for swimming pool encroachment, 11950 North Bay Shore Drive, and V-1123, a variance to the maximum allowed height of 115 feet in the BZ, I know what it is, zoning district, to a height of 3 feet dash 10 inches. And it's the same address, 11950 North Bay Shore Drive. Okay? So we're hearing all of them together.
So before we start, just note for the record that Ms. Pierre Lewis has
Thank you.
joined us. And Ms. Lewis, or Ms. Pierre Lewis, the board has already made disclosures with regard to contacts from the applicant or third parties. So if you have any disclosures to make, you can make them now. Okay, thank you.
All right.
Thank you, Madam Chair. As stated, the item before you is concerning 3 variance requests. One for encroachment of balconies into the side and rear yard setback and front setback. You have also a variance for the pool setback from the rear, and you have also a height variance. More specifically, you have a variance to Article 5, Division 1, Section 5103 of Chapter 29 of the City of North Miami Code of Ordinances, Land Development Regulations, LDRs, to allow for balcony encroachments in the side yard back by 5 feet, 1 inches to 10 feet, 1 inch, where 5 feet is the maximum permitted encroachment. Front yard setback encroachment by 1 foot, 1 inch to 6 feet, 1 inch, where 5 feet is the maximum permitted encroachment. Side yard setback encroachment by 7 inches to 5 feet, 7 inches, where 5 feet is the maximum permitted encroachment, and rear yard setback encroachment by 1 foot, 5 inches to 6 feet, 5 inches, where 5 feet is the maximum permitted at 19950 North Bay Shore Drive. Said variance is to be reviewed under the criteria set forth in Article 3, Division 6, Section 3-606 of the Land Development Regulations. Second item is a variance to Article 5, Division 1, Section 5111 of Chapter 29 of the City of North Miami Code of Ordinances, Land Development Regulations, LDRs, to allow swimming pool encroachment into the maximum rear yard setback of 10 feet to 6 feet, 6 inches at 11950 Bay Shore Drive. Said variance is to be reviewed under the criteria set forth in Article 3, Division 6, Section 3-606 of the LDRs. The last variance is to Article 4, Division 2, Section 4-203 of Chapter 29 of the City of North Miami Code of Ordinances, Land Development Regulations, LDRs, to allow a height variance to exceed the maximum permitted height of 115 feet in the BZ zone district to a height of 203 feet, 10 inches at 1950 Bay Shore Drive. Said variance is to be reviewed under the criteria set forth in Article 3, Division 6, Section 3-606. Thank you. So, dealing with the first one, you're dealing with the balconies setback. And this is V9-23. As stated, is at the property of 11950 North Bay Shore Drive. The property is approximately 34,275 square feet, which is approximately 0.787 acres. The applicant is requesting a variance to allow for the balcony encroachments as stated for the front, side, and rear. You have 6 criteria that we review as part of the variance request. The applicant would need to meet 4 of the 6 criteria. And those 6 criteria are as follows. Let me get to this. A special conditions and circumstances exist which are particular to the land, structure, or building involved, and which are not applicable to other lands, structures, or buildings in the same zoning district. 2, the unusual circumstances or conditions necessitating the variance request are present in the neighborhood and are not unique to the property. 3, that the requested variance maintains the basic intent and purpose of the subject regulations, particularly as it affects the stability and appearance of the city. 4, the literal interpretation of the provisions of these LDRs would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district under the terms of these LDRs. 5, the variance request is the minimum variance that will make possible the reasonable use of the land, structure, or building. 6, the granting of the variance will be in harmony with the general intent and purpose of these LDRs, and such variance will not be injurious to the area involved. So, as was stated earlier, you have a parcel that is approximately 34,275 square feet. It was in the BZ zone. The proposed variance is to allow for encroachment in the setback. As you can see here, the surrounding area to the north, you have multifamily. To the east, you have the intercoastal. To the south, you have multifamily. And to the west, you have single-family residential, as you can see by the aerial and you see by the map that is within the slide. The proposed site plan, this demonstrates the encroachments that in the red line that the balconies will have into the property, setbacks. This is a rendering of the building. So as stated, you have those 6 criteria that I went over as it related to the variance request. And with staff review, we looked at item number 1, are there special conditions? We say no. Item number 2, unusual circumstances or conditions necessitating the variance? No. Item 3, that the requested variance maintains the basic intent and purpose of the subject regulations, particularly as it affects the stability and the appearance of the neighborhood. The staff says yes to this. In this mindset, the land development regulations, the LDRs, allow for single-family, duplex, triplex, and townhome projects a variance to setback requirements where the setback is not decreased by more than 20% of what is required in the applicable zoning district. The variance is processed administratively through the city's decreased setback standards for primary and unattached accessory structures. These accessory structures encompass swimming pools, utility sheds, gazebos, summer kitchen, pool houses, awnings, utility sheds, and garages, etc. Consequently, although the requested pool setback variance for the multifamily development is nearly 40% reduction of the required setback, it does not affect the stability of the neighborhood, or does it adversely impact the city. The next criteria, the literal interpretation of these provisions of the LDRs would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district under the terms of these LDRs. In this instance, we believe no. It doesn't deprive the applicant of having a pool. It wouldn't deprive the applicant of being able to build. The variance request is the minimum variance request to make possible the reasonable use of the land, structure, or building. No again. This variance will not prevent the applicant from utilizing the land. Alas, the grant of this variance will be in harmony with the general intent and purpose of these LDRs, and such variance will not be injurious to the area involved. And the department says yes to this. As shared earlier, the proposed variance would not destabilize the neighborhood, and the granting of the variance would not be injurious to the area involved. With that in mind, with them not meeting the criteria of at least 4 of the 6, in this instance, staff recommends no recommendation for this item. However, if the board sees fit to grant this variance, we ask that the following conditions be observed: that the applicant obtain a building permit and all necessary licenses prior to the installation of the swimming pool, that all other standards of Article 5, Division 1, Section 5-111 shall apply, that the applicant adheres to all conditions provided by the Development Review Committee at the time of the DRC site plan approval, and that the applicant obtains certificate of use, business tax receipt, certificate of occupancy, and complies with all city, county, and state and federal regulations and laws. So the next item is, what are we doing here? Y'all forgive me. I was talking about pool, and there was balcony,
No,
y'all was going
I
along,
got
y'all
you.
going along. I was wondering why, Gasat was over here looking on the other side. So in the spirit of what's going on here, that's one of the items that we're gonna deal with the, see how we can and shape this out here. So as you've seen, we already know what we're dealing with. We're dealing with 11950 Bayshore Drive. You know the site plan, right here. You know the rendering is a lovely building. And you know the 6 criteria that we are dealing with, and you're dealing with the variance request. And this is applicable to all 3 of the requests. So staff has given no recommendation for this one. Should you have any prior, let's see what we're dealing with here. So this is for the balcony encroachments that you have on the site. As you stated there, you have those in difference. You have the front, the rear, and the side setbacks for the balconies. As stated here, you can see the different encroachments they want. The maximum encroachment that they're looking to have is by 5 feet more than is allowed. And we think in this instance, even though the applicant doesn't meet 4 of the 6 criteria, we look at this as diminutive as it relates to the impacts to the area. Specifically, as you're looking at it, in this aspect, we look at it looking at item number 3, that the required variance maintains the basic intent and purpose of the subject regulations, particularly as it affects the stability and the appearance of the neighborhood. The LDRs allows balconies to encroach into the required setback no more than 5 feet, but the balconies cannot protrude closer than 2 feet from any property line. Although the requested balconies variances exceed the maximum allowed encroachment by right, none of the balconies protrude closer than 2 feet from any property line. The closest balcony sets approximately 8.5 feet from the property line. Therefore, the requested variance maintains the basic intent and purpose of the subject regulations. The stability nor the appearance of the neighborhood would be affected. And the last one that we speak of, we think they meet, is to grant the variance will be in harmony with the general intent and purpose of these LDRs, and such variance will not be injurious to the area involved. Again, we say yes. As shared earlier, the proposed variance would not destabilize the neighborhood or affect the appearance of the neighborhood. Therefore, the granting of the variance would be in harmony with the general intent and purpose of these LDRs. And the requested variance will not be injurious to the area involved. That said, as stated earlier, the item you need is at least 4 of the 6 items need to be met or to get a positive recommendation from staff. In this instance, they meet 2 of the 4 of the 6, in our opinion. But that said, we still give no recommendation on the item. It's stated because of the impact that it would have on the neighborhood would not be injurious to the neighborhood and it would be out of harmony. However, if the board deems it fit to approve these variants, we ask that you consider the following conditions. That the applicant obtain a building permit and all necessary licenses prior to construction of the building, and that all standards of Article 5, Division 1 shall apply. That the applicant adhere to all conditions provided by the Development Review Committee at the time of the DRC site plan approval, and that the applicant obtains certificate of use, business tax receipt, certificate of occupancy, and complies with all city, county, state, and federal regulations and laws.
Are you moving on to the
I'm moving
pool
on to
one? I just have one question.
Sure.
And I don't know, it's not not trying to open discussion. Am I allowed to ask
Yes, you are.
clarification from?
Yes, you are.
I
You're in
just want-
charge.
I'm in charge. Okay. Don't say it too loud. Trying to understand, it's a lot of legalese. You know, I'm a simple person. I see the building and I see the balconies. All I'm concerned about, I know there are properties around. Will, if those balconies are built, will they be able, are they close enough, I should say, to be able to see into the residences that are around if a person is standing on the balcony? That's all I,
So, if you remember the aerial that we have, if you look right here, it's up, and hopefully the screen is still up. You have to the north, you have a multifamily residential. So you will be able to see next door. You know, you would be able to see south, and you will be able to see to your west. To your west, you have single family, but they do have a buffer there. They have a right-of-way, they have a vacant lot, and then you have the first resident. And to your east, you have the intercoastal.
no. So they're not like right next to each other.
Well, you have the property lines. They have the minimum setback that they
Okay.
need to have from the property line. And if you recall, when I was talking about the encroachment, the closest balcony to any property line is 8 feet from the property, 8.5 feet approximately from that property line.
Okay. Thank you.
So, I went over the pool. Y'all want to go to the pool again?
We'll go to the pool.
Okay, let me go to the pool.
Did you,
So this is just an overview. This is the
Yeah.
pool area. It's at the rear of the property, adjacent to the intercoastal. The code minimally requires from the rear property line, you need to have 10 feet. They requesting a deviation of 5 feet, so they can be 4 feet, so they can be 6 feet away from that property line. And that is the extent of it. We are not making any recommendation. It's hard to meet 4 of the 6 criteria when you don't have a hardship. They just doing this because this would give them the best layout, the best ability to be able to develop the property, and they're looking for this deviation so they can have an aesthetically pleasing area for their residents and others in it. It is not going to it's not going to have an impact on the area, and it's not going to be out of harmony. As I stated in my conversation, that it is not uncommon throughout the city that we give deviations in pool setbacks. It's very common. And it's usually administratively, not at this extent, but you can see this is isolated where it's located at the rear. Now the important variance that we have on the docket. So, as you know, the applicant is seeking a variance to the maximum height. And this is item V1123. This is again located at 11950 North Bay Shore Drive. The applicant seeks a variance in the BZ zone, which allows for a maximum height of 115 feet. They're seeking a height variance to 203 feet, 10 inches. As stated, you know the site is approximately 34,000 square feet. It's in the BZ zone, and they're seeking for that, even though that says it incorrectly, it's seeking for a deviation in the height. So, as you know, to the north, you have multifamily. To the south, you have multifamily. To the east, you have the intercoastal, and to the west, you have single-family residential. The site plan, as you are familiar with from the other slides, is here. You see that it is quite an elegantly laid out site plan. Here are some the east to the west elevations that you would see. This is what you would see from North Bay Shore Drive. This is what the single-family residents would see looking to their east. And then a rendering, as you can see here, of the building. And this is looking from it also from the north, southward to the building. So you know we have 6 criteria that I went over earlier about this project. And you also understand you need to meet 4 of the 6 criteria to get a positive recommendation from staff. So when staff reviewed this matter, of course we say, are there special conditions and circumstances that exist which are particular to the land? You're going to be building a new site, so there's no particular reason why I need to raise the height. In the applicant's letter of intent, and they will go into it eloquently in their presentation on why they need it, is to be able to accommodate the density that is allowed for the site, to be able to fully manifest how many units they want to have in there for the site. That's not grounds for a variance. We need more housing in the city. More housing would help generate, maybe bring down the cost of housing if we have more units and get a surplus. So we welcome the opportunity, but that's not grounds for a variance request. Are there unusual circumstances or conditions necessitating the variance request are present in the neighborhood and are unique to the property? Not particularly unique situation there. You know, you're building anew. You know, you can accommodate the, say, you're still looking at height. We're not even talking about encroachments into the side and stuff like that. We're just going upward. Number 3, that the requested variance maintains the basic intent and purpose of the subject regulations, particularly as it affects the stability and appearance of the neighborhood. Again, we have a no here. And in this moment, the staff felt it was imperative to go into a conversation on why we feel this is the case. Although another multifamily building exists in the BZ zone district that exceeds the maximum height allowed by 115 feet, with an estimated height of 169 feet, the Moroka Towers was constructed prior to the establishment of the BZ zone district. Further, the building stands as the tallest building in the BZ zone district. The applicant also references another building outside of the BZ district, situated approximately 1,500 linear feet west of the subject property, known as Bayview Towers Condo, located in the R4 zoning district with an estimated height of 189 feet. Both the Marioka Towers and the Bayview Towers are legally non-conforming structures constructed prior to the institution of their respective zoning districts. Both structures represent outliers to their respective zoning districts, with the Marioka height exceeding the BZ district maximum height of 115 feet by 54 feet. And the Bayview Tower exceeds the R4 maximum height of 35 feet by 155 feet. The Marioka 169 feet represents approximately 2/3, 32% increase above the BZ maximum height allowed. And the Bayview Tower, 198 feet, height represents 81% increase above the maximum height of the R4 height. The proposed variance does not represent the intent and purpose of the LDRs by perpetuating projects development that deviate from the maximum height. The next one, the literal interpretation of the provisions of the LDRs would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district under the terms of these LDRs. No, again, a variance is a mechanism used to mitigate hardships that restricts the property's owner ability to develop the property. The variance is not a tool of convenience to circumvent the development standards of the zoning district to allow the fruition of a development proposal to deviate from the development standards of the zoning district. The granting of the variance establishes legal precedents that enable future property owners legal grounds to secure the same variance. As such, because two legally non-conforming buildings exist in the proposed development site general area that exceeds the maximum allowed height of the BZ district does not constitute circumstances that represent grounds that property owners is deprived rights commonly enjoyed by others that to exceed the maximum allowed height. Further, two representations of height deviations do not reflect rightly commonly enjoyed zoning district. Two buildings represent exceptions in their respective districts. From this understanding, the appropriate apparatus to exceed the height change is through a text amendment of the LDRs to change the BZ district maximum height from 115 feet. If approved, the text amendment would establish continuity within the BZ zone. The variance request is the common variance that will make possible reasonable use of the land structure. And again, no. You don't need a variance height to be able to use this land. It doesn't prevent them from building. You just need to build at 115 feet. And last, the granting of the variance will be in harmony with the general intent and purpose of these LDRs, and such variance will not be injurious to the area involved. Again, no. As shared, although another building exists in the BZ zone district that exceeds the maximum height, it is not representative of the height in this district. The proposed variance request is of 203 feet, 10 inches, constitute a height increase of 88 feet, 10 inches, representing a 43.5% height above the maximum allowed in the BZ zone of 115 feet. Additionally, the requested variance denotes a height increase above the Myoka Towers, 169 feet by 34 feet, 10 inches, representing a difference of 17%. The variance request does not promote the general intent and purpose of the LDRs. A variance is intended to mitigate hardships as stated earlier, not to create it by the property owner. Variance is not the tool to facilitate development standards changes. LDR amendments are intended to execute standards and regulation changes. With that in mind, the applicant has requested the height variance from the maximum height permitted in Article 4, Division 2, Section 4-203. Excuse me. Please silence or cut off your phones, please.
That's a conversation.
It was just conversation.
Excuse me.
Stop.
Conversation?
Yeah.
We can hear you. Thank you. My apologies. My apologies
go ahead.
to you too, but we have a proceeding. Just for the sake of clarity, remember this is a quasi-judicial proceeding. You should treat this like you're in a courtroom. Thank you. The applicant has requested a height variance from the maximum height permitted in Article 4, Division 2, Section 4-203, seeking an increase from 115 feet to 203 feet 10 inches. After careful consideration of the standards outlined above, staff recommends a denial of the requested variance height.
Hold on, Mr. Cook. Guys, you cannot do this. Nou la, nou pa ka blan téléphone, nou pa kapab pale. Si nou te lan tribunal, nou pa kapab fè ça. Seriously.
Thank you, Madam Chair. So after careful consideration of the standards outlined above, staff recommends denial of the requested height variance, in that when no hardship exists, the appropriate mechanism to institute a development standard change is through the LDR's text amendment. However, should the board grant the variance, staff requests that the following conditions be included. That one, the applicant obtain a building permit and all necessary licenses prior to construction of the building, and that the applicant adheres to all conditions provided by the Development Review Committee at the time of development review site plan approval, and that the applicant obtain a certificate of use, business tax receipt, and certificate of occupancy, and complies with all city, county, state, and federal regulations and laws. Thank you.
And we welcome the applicant.
I'll give it to the clerk.
And you can go ahead and state your name and addresses, please.
I'm not. It may be.
Good evening. Pedro Gaston of Holland Night with offices at 701 Brickell Avenue. I'm joined this evening by my colleague Alessandra San Romain, also of Holland Night, as well as by representatives of Alta Bayshore, the property owner and developer for the site. As you can imagine this evening, I have a lot of respect for your community planning department, but as you can imagine, I disagree with every aspect of what they were talking about with respect to the variance criteria. Tonight, I want to speak to you first about what we are not talking about. We are not talking about density. We are not talking about traffic. We are not talking about site plan or landscaping. None of those items are before you. Those items will be handled by the City Council at a later date. Tonight, what is before you are 3 sets of variances, one relating to setback variances for balconies, the second relating to a rear setback for a pool that this board approved previously for the same exact site, and finally, one relating to height. At its core, and in our simplest form, our presentation boils down to a very simple legal concept. Irregularly shaped lots are entitled to variances. If you don't remember anything else about what I talk about this evening, I want you to come away as an expert in variances with respect to irregularly shaped lots. Not only will I talk about it, I won't just give you my opinion, I won't just advocate on it, but at the end of this presentation, I will present you with a case that talks about the approval for a height variance and setback variance based off of an irregularly shaped lot. This will not be the circumstance of me just giving you conjecture and rank opinion. It will be based both on case law, the facts, and your code. Next slide, please. This is the property. It is located just south of Northeast 120th Street and immediately east of Bayshore Drive. The property is approximately 0.79 acres and has an irregular shape. Next slide. This is a closer view of the site. The property is sandwiched between two properties on the north and south, and it's also sandwiched between Bayshore Drive and the bay. You can see the curvilinear feature of the site on the east side continuing south that creates an irregularly shaped parcel. If you cannot describe the shape, it's irregularly shaped and would be entitled to a variance. It is this configuration and irregular shape that serves as the basis for our variance request tonight. And as I will explain to you, this helps to demonstrate why we meet the variance criteria of your code. Next slide, please. Your code, as Derek has mentioned, references 6 criteria for approving variances. Pursuant to the city's code, we only need to demonstrate 4 out of the 6 in order to be entitled to approval. Tonight, I'm not just going to show you that we meet 4 of the criteria. I'm going to show you how and why we comply with all of the criteria in the city's code. One by one, you will see in this presentation how we satisfy each criterion of the code. The next several slides will first start off with identifying the specific criterion, and then we will identify how we comply. This is variance criterion number 1. We have to show that there are special conditions and circumstances that exist which are peculiar to the land, which are not applicable to other lands, structures, or buildings in the same zoning district. As I have stated earlier, the special condition impacting our land is the irregular shape of the lot. This irregular shape is peculiar and specific to our lot. No other land in this area or in the zoning district has the same shape. And to bring this point home, I'm going to come back to the aerial. You can just look at it. We have essentially 3 properties in the BZ south of Northeast 123rd Street. The property north of us and the property south of us. The only property with our irregular shape is our site. And as a result, we qualify under criterion number 1 of your variance code. Criteria number 2. We have to show that there are unusual circumstances or conditions necessitating the variance requests are present in the neighborhood and are not unique to the property. In this instance, one of the things that's unusual about this property is that we have a right-of-way in our front and a right-of-way behind us. The bay is behind us and North Bayshore Drive is in front of us. This is an unusual configuration. In most communities, you do not have a right-of-way behind where you live and a right-of-way in front of where you live. But in this neighborhood, in Sans Souci, this is something that permeates all throughout the community. Next slide. So you can see the majority of this neighborhood has right-of-way in the front and right-of-way in the back. This is not peculiar to the site. So pursuant to your code, I can only read the language of your code. Your code states that in order to qualify for it, it needs to be something that permeates throughout the neighborhood and is not limited to our site. The condition that exists today with the road being in front of us and the bay being behind us permeates all throughout the neighborhood of Sans Souci and therefore demonstrates that we comply with criterion number 2. Criterion number 3 requires us to analyze whether the variance maintains the basic intent and purpose of the city's code, particularly as it affects the appearance of the city. And on most of the items, Derek said no, but on this item, on some of the variances, he said, you know what, it does meet this because this is an enhancement with respect to the appearance of this property. This variance boils down to whether the project maintains and enhances the appearance of the city. This project, without a doubt, enhances the appearance of the city, especially when viewed from the bay. This is the project. When you're on the bay, one of the issues that occurs is that you have properties that have been built in the late 60s and the early 70s. Enhancing the appearance of the city from the view of the bay is one of the aspects that this property and this development helps to address. Because what we are doing is we're providing a luxurious design, luxurious amenities, and unobstructed bay views. Given its enhancement to the appearance of the city, the lot and the circumstances of our development satisfies criterion number 3. Criterion number 4. This essentially boils down to whether the regulations as they exist today will deprive the applicant of rights commonly enjoyed by other properties. And without a doubt, there are properties that do not meet the setbacks or height provided in the current LDRs. Now, Mr. Cook talked about how the current zoning code does not permit the height that's existing in Majorca, and therefore it's an exception. But your code language specifically says as permitted under these LDRs. That height that exists in Majorca is permitted under the LDRs because it's a legally non-compliant site. As a legally non-compliant site, your code recognizes that that site is allowed to continue to exist, and it recognizes that that site is something that's permitted by the code because it's legally non-permitted. It's legally non-conforming. So as a result, for this criterion, we're not talking about the fact that we just have some sort of exception. We're talking about a development trend where developments within the area are not complying with the height of the zoning code within the BZ structure. And as we'll show you, one of the first things you can see, which is pursuant to your code, the first thing you see when you look at the site is that the pool for Majorca Towers, like the pool we're seeking here, is in contravention of your setback. It's clearly in contravention. It's immediately next to the rear. In addition, the height does not comply with the height permitted within the BZ code. That development trend of not complying with the height is the basis for our ability to demonstrate and seek a variance of the height perspective with respect to the city's code. Next slide. In addition, you'll see that it's immediately south of us, and that property is 169 feet. Next slide. In addition to that, Bayview Towers, which is 189 feet, also does not comply with any code requirements for the zoning district within which it is located, because that property does not comply with the height standards of the LDRs, but it's still permitted under your city's code because it's a legally non-conforming use. Next slide. Variance number 5. The variance requested is the minimum variance that will make possible the reasonable use of the land, structure, or building. Now, a lot of you on this board are real estate experts, so I do not have to tell you the market that we are in and the issues that we are dealing with respect to bringing projects to market. But for purpose of the record, I will do so. Anyone who knows about constructing luxury condominiums understands that they require first-rate materials. And as everybody in here knows, the cost of construction, the cost of insurance, and the cost of mortgage interest rates have all skyrocketed over the last several years. So it creates an interesting dichotomy. You have the cost of construction that's going up, but then insurance costs are going up as well. Whenever you have insurance rates going up, that reduces the price at which a consumer is willing to pay. So you actually have to be in a position to provide for higher rate buildings to get the type of price that's going to make sense for the site. Next slide. But in addition, we are seeing the highest interest rates in this country since December of 2000, the highest interest rates for over 2 decades. To put this into perspective, in December of 2000, I was still in middle school. We have not had the type of interest rates that we're seeing and that we're facing. So you have the cost of construction going up, you have the cost of insurance going up, and you have the cost of borrowing going up. So you have to be able to demonstrate and develop a construction mechanism that's going to be able to provide for a feasible development scheme that will make it make sense for the reasonable use and development of this project. And the only way to do that is to be able to have this height, to have this design, and to have these high-scale amenities and luxurious design that we're providing as part of this project. This project is a first-rate development incorporating premier materials and world-class design. It features unimpeded views of the bay, significant glass to accentuate the beauty of the bay while incorporating the highest scale of amenities. This is the only type of development that can be built during this time of increased rates and construction costs. Therefore, criterion number 5 is satisfied. Next slide. The final criterion essentially asks us whether the variance will be injurious to the area involved. The answer to this criterion is an emphatic no. This criterion will not be injurious because what the project that we are developing is going to be in furtherance of the city. Next slide. One of the first things that we're doing is we have made a commitment to provide $100,000 to Bill Lehman Park. That commitment is part of the Shoreline Development Review. That's already a resolution that was created, developed, and that's already as part of the file with respect to this project, where we have a base built-in commitment for $100,000 for Bill Lehman Park. Next slide. In addition, the project stands to have a substantial positive impact. The average unit is expected to sell between $1.7 million and $3.5 million. And our economic report estimates over 1,400 jobs during construction and over $8 million annually from the residents of the project. But that's not all. Next slide. Over a 5-year period, the city will be receiving over $8 million from this one project, over $18 million over a 10-year period from this one project, and over $43 million over a 20-year period. Given these substantial benefits, we meet criteria number 6 and are therefore entitled to the approval of our variances. Now, these are our variances. We are seeking a height variance, several balcony variances, and a rear setback variance for the swimming pool. The rear setback variance for the swimming pool was already approved by this board for the same exact feat. So I cannot comprehend what would be the basis for denying the pool. In addition, when we're talking about the irregularity of the shape of our lot, there is case law to support the basis for our approval. And one of the aspects with respect to the height request that we're seeking is that it helps to ensure that we're providing for the sea level rise issues, addressing higher elevations, and being in a position of being more resilient with respect to the development. Next slide. Now, as I promised at the beginning of my presentation, I was not just going to stand up here and tell you about my opinion. I wasn't going to just say that we meet the variance criteria, that because it's an irregularly shaped lot, that it complies, and therefore it should be entitled to approval. The case that I'm going to be citing to you, and the case that has just been passed out by my colleague, is a case of the City of Coral Gables v. Gary. And this case essentially stands for the proposition of exactly what we're seeking today. Now, I'm going to set the stage with respect to the facts that are involved in this case. And what we've done is, for your convenience, is we've highlighted the pertinent aspects of the case. Specifically, these are the facts. The variances, which deal with setback requirements and building and wall height limitations. The unusual shape of the plaintiff's property rendered it simply impossible for it to be developed in accordance with the existing regulations. Next slide. And this, for me, is the core aspect of this case. The case that's before you is over 30 years old and has been precedent in this district in Miami. It is, of course, well recognized that the irregular shape or other peculiar physical characteristic of a particular parcel constitutes a classic hardship, unique to an individual owner, which justifies and in some cases requires the granting of a variance. So in this case, as I stated at the very beginning, because we have this irregular parcel, because we have this irregularly shaped lot, we are entitled to the approval of this project. We thank you for your time. We appreciate this opportunity to speak with you this evening. We are here to answer any questions. Because we believe that it's consistent with your criteria, because we believe that it's consistent with your code, and because we believe that it's consistent with the case law, we believe that our variance request should be approved this evening. Thank you so much. I'm here to answer any questions and would like to reserve some time for rebuttal. Thank you.
Thank you.
Madam Chair, if the staff can rebut.
I'm not
I was
sure.
going to ask you a question, but you had something to add.
Yes.
Okay.
Of course, he's entitled to.
Yes.
To rebut the
Yes.
applicant?
Yes.
Sure.
Okay, well, we have a
Providing
different
Please.
of appearance.
Okay. So I will concede that the irregular shape of a lot can be standards for a deviation of the code. But I think it's an important element that the client pointed out. He says, and it didn't say absolute, it said it may be a cause for a deviation.
That's not what it says.
But read the word at the
It
end.
says justifies.
No, read the whole statement.
Okay.
Toward the end. For the sake of clarity, if you
And
would.
we understand on the board
Yes.
that, and
Through the-
cases
through the
like
chair,
that
through the chair.
have already come in front of the board where we had to consider shapes of lots. But
Yes.
my question,
Yes.
and it's because the applicant refers to it a couple of times, that BZ district
Yes.
with the 115 feet that was set, do you know in what year?
Can I add?
I'm sorry.
Can I add to that question?
Yeah,
In what year was Mallorca Towers built?
and that was my next question.
And in what year was BZ set as the district?
Madam Chair.
Yes, Mr. Help.
Give me a moment here. And
Uh,
I-
uh,
1960
All
Hold on.
information has to be on the record, and if you can wait your turn. So, Madam Chair, if I can, I have a few comments to make as well.
Go ahead.
Okay. Well, first, Ms. Pierre Lewis has shared with me that she resides in the area and asked whether she has a conflict and needs to disclose it. And I have advised her she does not have a conflict based upon my understanding of the number of people that would be affected by the proposed project.
Okay.
So, just
Yeah,
say
okay.
you agree on the record.
Yes, I agree.
Okay. So, council cited the case of City of Coral Gables versus Geary, which is decided by the Third District Court of Appeals in 1980. There's a subsequent decision by the Third District Court of Appeals in 1993 that distinguishes Geary, and I'd like to read some statements by the court to clarify that distinguishing. Okay? So this is, quote, Florida courts have held that a legal hardship will be found to exist only in those cases where the property is virtually unusable or incapable of yielding a reasonable return when used pursuant to the applicable zoning regulations. Thus, in City of Coral Gables versus Geary, the 1980 decision, this court applied the granting of certain variances based upon the finding that the unusual triangular shape of the property constituted a hardship because it was virtually impossible to develop the property in accordance with existing regulations.
Yeah.
We further explained in Geary that the hardship must arise from circumstances peculiar to the realty alone, unrelated to the conduct or to the self-originated expectations of any of its owners or buyers. In this case, the 1993 case, there were 7 lots contiguous to each other, and there was some irregularity in the layout. So applying these principles to the present case, it is obvious that here, and I suggest in the case before you, unlike in the Geary case, the shape of the property in no way constitutes a legal hardship.
No.
2 other comments. The subject property cannot rely on legal nonconforming uses or structures on other properties to establish a right to a height variance merely because those legal nonconforming uses or structures are provided for in the LDRs. There's no continuity to an adjacent parcel that justifies the legal nonconforming status to be conferred to the adjacent property. If there's a reason otherwise for establishing some consistency in the neighborhood or something like that, but you cannot look at the language in the LDRs dealing with legal nonconforming uses or structures as a basis for that hardship. The whole argument about being the bay being a right-of-way in the back is not such you can take judicial notice of that. It's a very common experience for properties to have the bay behind it and a street in front of it. So I'm available for any questions to clarify any of that.
Okay, what about the question that we
Hold
asked?
on. We had a question with Mr. Cook. I think he's looking at it for us.
When I go to the property appraisal site, because it is a condo and they all have individual folio numbers, it doesn't give the actual date. So I have to refer to the residents on the specific date of the build.
Gentleman
And my-
right now.
Yes.
You
Come
have
to
to
the
come
mic.
to a microphone, identify yourself, and confirm that you're sworn.
Yes, he was.
Thank you. My name is Hernando Barreto, resident of North Miami. I live in Mallorca Tower. Mallorca Tower was built in 1968. The current LDRs of the North Miami were issued in 2009, and the BC district zone was adopted in 2018 by ordinance number 1444. Then it's very common in law, local, state, and federal law, that there are, when new regulations come for a good cause, could be grandfathered situations
I'm going to
that
object.
exist
Hold on.
before
I'm gonna
that.
object. I'm going to
We're,
object.
yeah,
Save,
That's what
save
I
the
was
rest
saying.
for your presentation.
for your
if you-
public comment.
Thank you.
Thank you. So 1969 and 2018. Okay.
Were there more questions?
Any more questions for Mr. Cook? Mr. Cook, are we okay with
I have
the
plenty of
gentleman?
questions, but
I
I'm
want to
sure we'll wait
confirm
till
the date
For
on
Mr.
the
Cook?
BZ zone, because the BZ zone couldn't have been 2018, except it was before I arrived, and I arrived in 2018.
Okay,
Yeah. It had to be 2009 and when we did the most comprehensive update of the zoning district.
okay. Keep
It-
looking.
I'm
And what I'm
gonna-
gonna do is probably at this time, open up public hearing.
I just want to know for the record that I'm going to object to the entire statement that the individual made, being that it's not consistent with what the zoning director, and we
Well,
don't have any verification. I just have to object for the
He's a
record.
resident, he's gonna make his
That's fine.
thing, you know, and whoever wants to come up will say what we say,
Un-
and as
understood.
the lawyer says, only take what is fact. Okay,
I do have one quick follow-up. To that point, if there were already legally non-conforming assets in the district, in the BZ zoning district, and then in 2009, there was a set for 115 feet as max height, why exactly was that set, given that there were already Mallorca Towers that was already built that was at 169 significantly over and above that threshold?
Control height, that's why.
yeah.
Why did that happen?
Maybe council at the time and people who were making decisions for the city, trying to control the height and, you know, the type of building that we were going to have. But I don't want to prevent the residents who are here to speak. I need to open a public hearing so they are able to say their piece. And then we'll
And are-
continue with our discussion later.
Are the residents speaking to all items at one time?
Yeah, since we have taken all of them at one time. So, we will open up public hearing. I will really seriously suggest that we stay to, what is it, the 2 minutes or 3 minutes that we had, 2 minutes that we get, because it seemed like there are a lot of people here. And I know people want to say things, but sometimes when you hear the same repetitive thing, if somebody's saying the same thing, maybe we need to consolidate so that we can come to a decision. We know who's here, how your feeling is going. I don't want to stop you, but I just want to say in fairness, so that we can keep this proceeding and we're not here till 2 a.m. Okay? So, public hearing is now open. You can have either microphones, come in, state your name and address, and say your piece. No, come on up. Next person can come to that. I'm sorry?
I will appreciate
I
to
will
have a
s-
little bit
sir,
more
I
than
just
2
want-
minutes
Hold
because the
on.
gentleman had
Hold
30
on a
minutes
second.
to present the project.
Hold on.
Sir, I just wanted to let you know and all the speakers that I will give you a 30-second warning.
Okay.
Okay, my request was if I can get a little bit more than 2 minutes. That has happened in previous meetings because the gentleman has 30 minutes to present.
No. He is representing the applicant.
Okay.
You, as a resident who has something to say, we can only give you guys 2 minutes. I'm sorry.
Okay. Although we are talking about variance, it's very relevant to understand what is behind the scene, the scene
Name
for
and
the
address for
developer.
the record, please, to start.
Oh, excuse me. Okay, let me start again. My name is Hernando Barreto. I am resident at Mallorca Towers, 11930. North Bay Shore Drive.
Okay, now you.
Okay, it's very relevant as you have received in the emails. I sent one and many other residents sent. What is behind this request for variance, trying to circumvent the actual process to zone change? That's what they also are looking to change the density, and as they presented, and as I will appreciate to consider the video of the meeting on August 8th as a proof, because this is that they are trying to do a 96 building in a space that is only allowed 78. Now, as already the staff mentioned, the variance procedure is not the legal avenue to intend a zoning change. That is what they are trying to do. 88 feet and 10 inches is actually 78% more than the 115. The variance procedure is established for the small changes when there is a hardship, which is not. In the case of Coral Gables that the gentleman presented,
30
there was
seconds.
no option to develop. In this case, they can develop. Then more than 100 residents has already voiced. I will give you a copy in order to make official of the email and the letter that we submit. More than 100 residents in the area oppose this variance, specifically in the height, because exceed the purpose and the intent of the LDR, which was
Sir,
issued.
respectfully, that's your time.
Okay,
I'm
thank you.
going to object to the, I have to object.
You
I have to object
cannot,
this.
sir, that's not how we handle it.
Okay.
We allow the residents to speak, and then we can come back, and then there'll be discussion from up here.
The only reason I have to do it is just for the record, Madam Chair, is that I want to object to the extent that he's trying to get documentations that's outside of the scope of this hearing, to the extent that he made representations about legal issues, and he's not a lawyer. I'm going to object. I just need to state it for the record. Thank you so
Okay.
much.
I understand. Next person. State your name and address.
So, anybody who intends to speak on this item, we have 2 podiums available. Please come up
Were you sworn in?
so we can move about this quickly.
She needs to be
'cause-
sworn in. They all need, she wasn't sworn in the first time.
Hello, madam. Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth in these proceedings?
Yes, I do.
All right.
Good evening, Karen DeLeon, 1935 South Hibiscus Drive. BZ was created specifically to keep height at the height that the residents wanted in that area. I think everybody's familiar that the White House Inn, which was represented by the gentleman behind me, they didn't ask for a variance for that, and that really is more of an irregular shape. We would like you to, we appreciate that they're being creative, we appreciate the economy, we appreciate all of that. But we do the LDRs as a community to say that this is how we want our area to look. And we're asking that you follow staff's recommendation and that you deny the variance for the height. Thank you.
Next person. Anyone else? And I hope these are individuals who will be impacted by this area.
Good evening, Mrs. Chair, Mr. Vice Chair, and member of the adjustment. My name is Leon Latorche. My address is 13517 Memorial Highway, North Miami, Florida. I'm here tonight in support of the proposed variance of balconies, swimming pool, and high increase at 11950 North Bayshore Drive. After reviewing the details of the project, I found it an excellent opportunity for the residents of North Miami. To begin with the project, we eliminate the slums and blight in that area. Secondly, we will have a financial windfall. Thirdly, the project will be create thousands of job opportunities for North Miami residents. For the reason, I respectfully ask you to recommend approval of the variance. Thank you.
Good evening, Chairwoman Phillip, Vice Chairman McDermott, and members of the Board of Adjustment. My name is Kiana St. Louis. I reside at 15605 Northwest 2nd Court in Miami, Florida 33169. The city is constantly coming after me for more property taxes, sewer fees, water fees, and so on. I was told that the city kept coming after us because they don't have development like this that will give them $50 million in 20 years and new property taxes. So I'm not sure if we should, how we can touch this city for development, but I would like to encourage you to approve this project. Thank you again for allowing me to address this evening.
Good evening, Ms. Chair Rosalind Phillip, Vice Chair Michael McDermott, and members of the Board of Adjustment. My name is Flora Dubois, and I've been a resident of North Miami for the past 32 years. I'm here tonight in hope that you will join the hard-working residents of North Miami by recommending approval of the requested variances. Our city can be a powerful voice in the light that will protect our residents, provide a healthy economy, create opportunities for all. So we need to fight back. We cannot let just a few people continue to prevent us from moving forward.
May we have your address?
15605 Northwest 2nd Court.
Okay, thank you.
I'm in Miami. That's Miami, Florida, 33169. Okay.
Thank you.
So we have to stop chasing ghosts. You know, the city looks exactly the same as it did 50 years ago when I was a little boy. After 50 years of being untouched, we are left as the last uncharted territory for development. Councilman Calvin said, these are not my words. So by recommending this project, our city will join other cities in creating jobs for the
30
residents, safer North Miami, better environment, fixing our broken roads, and eliminate slums and spikes. Thank you for considering this project.
I'm John Stewart at 12,000 North Bayshore Drive, apartment 411. I'd be in an apartment closest to this development on the north side. The residents, we have 46 condos in my resident, and they were very against the redevelopment plan for this property 4 or 5 years ago. I don't think anybody would be opposed to it now, changing the variance. Thank you.
Good evening, Ms. Chairwoman and member of the Board of Adjustment. I reside at 11855 Northeast 121st Street here in North Miami. I am here tonight in support of the proposed variance at 11950 North Bayshore Drive. After reviewing the details of the project, I found it to be an excellent opportunity for the residents of North Miami. I respectfully ask you to recommend approval of the variance. Thank you for your support.
My name is Hal Schoenfeld. I live in Majorca Tower, 11930 North Bayshore Drive. We had a local community meeting at Temple Beth Moshe about 2 months ago. And they made a presentation, and there was strong opposition. You sensed it. The crowd was not happy. And what I'm disappointed about is I understand that they changed the height variance several times. That's what I was told by email. And now, after hearing our opposition, they stuck to their guns. No reduction, no flexibility. We have to make money with them. and maybe we don't want to make the money. That's our, we want to keep a nice community with no traffic, because it's getting bad. I moved from Broward County back here, and it's completely different. Thank you.
Hello, my name is Mary Pierre Louis. My address is 11305 Northeast 12th Avenue. On behalf of the citizens of this city, I would go for the project. I believe the project will help the community. It will create a lot of jobs, a lot of job opportunity, and more tax, and more opportunity for the North Miami residents, especially parents like me, single parent like me with 3 kids. So I'm for the project. Thank you.
Mr. Mayor.
Good evening, board members, Mr. Held, staff. I'm Frank Woland. My office is at 12865 West Dixie Highway. I represent DPZ 306 LLP, which owns property right next door to this property, 12000 North Bay Shore. I'm here to urge you to vote in favor of the variance. I believe that it is in the best interest of North Miami and that it has the potential to allow the city to use what I think is an incredible economic engine. There are 7.5 acres right there on the bay. And you can go up and down the bay and you'll see they're going to be building 50 and 60-story buildings. And this is nowhere close. And it's another 30 feet bigger than Majorca Towers, which is next door. They're going to build 96 units. They're going to cost $2.88 million each. What is that going to do for our taxes? $1.5 million in impact fees the year they build it, $1.147 million every year for taxes, $1.2 million for the county, $1 million for the school. More than $3 million every year for police officers, for school teachers, resource officers, park people, librarians. Respectfully, it's not going to use city resources, but it will contribute to making our city better for everyone. It will contribute to our tax base, and I urge you to support it. Thank you so much.
Anyone else? Yes, then that's it. If you can just sort of like line up, let me see, because I'll be closing public hearing soon. Okay.
My name is Dickinson Solomon. I reside at 11855 Northeast 19th Drive, and I attended school at Alonzo and Tracy Morning Senior High School. And I strongly support this project of the City of North Miami. I want to thank you again for making jobs, lowering taxes, and a safer North Miami, and repairing our roads. This project will provide millions of dollars of new taxes to the city. Lots of jobs will be created, and we will have a safer city, and our streets will be repaired. Thank you for supporting this project.
Thank you.
Hi, good evening. My name is Curtis Darrow, and I reside in 111-900 Northeast 16th Ave, and I'm in support of this project, and let's do something new with this city. After 50 years, we've been untouched, and we are the last one to be untouched, and I feel like we should have a better development. Thank you for your service.
Good afternoon, good evening, Madam Chair, Mr. Vice Chair, members of the Board of Adjustment. My name is Jeff Lozama. I'm a small business owner located here at 713 Northeast 125th Street. I'm here to seek your approval on the few minor variances and the regular variance to increase the height of the building from to 103 feet. As you've already heard and well articulated by the attorney, there is a building just a block away that is 190 feet, about 190 feet, and none of the variances, as he articulated, will have any adverse impact on the community. So we all understand the need for housing in South Florida, and we know for sure that this project will help curb the high demand of housing. Also, architecturally, as we saw on the pictures that were shared on the screen, this is a beautiful project, and it will bring value to the community in the area. And economically, as a small business owner, I know this will create a lot of jobs for the city, for residents of the city, as well as with the right local preference, it will give opportunities to a lot of small contractors to participate and create jobs for folks in the area. Thank you, and I'm seeking your approval for this project.
Thank you.
Hello, my name is George Balezin. I live to North Miami, 13155 Northeast 6th Avenue, apartment 2. Reason because I support the city, because I think the project is very good for the city. I think it's very good for the city, because I just support.
Thank you. Okay, this young man will be our last one, I guess.
Best for last. First, I'd like to start off with saying great evening, ladies and gentlemen. I really am glad to see a lot of people out here because this is our city. I also like to say great evening to the chairmen and women that are here, taking their time out their day. My name is Andre Pierre. I reside at 2125 Northeast 121st Street. So I'm literally 1 block away from the property. Excuse me. What makes a city great? If you look at the top 10 cities, what makes them great is the policy that they put in through their CRA. And when you look at cities like New York City, Chicago, San Francisco, Hollywood, California, these cities are great because of how they improve the structures of the buildings and how they're able to build and bring in the community to help in with the projects. Number 2, I would like to say is that there's been a lot of talk about like the Beth Moshe because the developers actually came and talked to the neighboring community that actually affects us. And I mean, at the meeting, I was there and there was a lot of commotion and things like that where the developer was trying to go through his project. And then, you know, there's always people that are against things. So, I mean, there was not a lot done, I would say, in my opinion, at the Beth Moshe meeting because there was a lot of argument and things like that and nobody was able to get anything said or through. Lastly, I just want to say the BZ zoning, say that again?
30 seconds.
Okay. Lastly, I would like to say the BZ zoning happened in 2009, which is about a decade and a half, well, not a decade and a half, but about a decade ago and some change. And as you can see, when you look around the room, there's a mix between old, young, and, you know, people in the middle, not to call out all the old people. And I just want you guys to take a look and have an idea of where this city needs to be for the future, for whether it's your kids,
Respectfully, sir,
grandkids.
that's your time.
Thank you for everything. Have a great day.
Thank you.
Okay, did you said 2? Gentleman over there, I saw you got up. You need to speak in the green shirt. Oh, okay. Come up to the mic. Oh, okay.
Good afternoon. I mean, good evening. Right now it's about 7:45. My name is Andre Pierre. I reside at 2125 Northeast 121 Street. I used to serve on this board when I was a young man, when I had hair. Also serve on the Planning Commission, the Charter Review. So I want to say thank you for serving. I know it's a lot of time reading all these materials. There was about 300 pages of material that were sent to you. But just briefly, I just want to go into 3 different areas. Okay, last month we were at the Latin Builders Association annual luncheon or monthly luncheon. There was about 1,000 folks that were there. Okay, the president of the association said, Andre, we have 3 problems. Okay, we have problems that call interest rate, that's going through roof. We have the problem of cost of construction, that mid-level, up so far, and we have the cost of labor. He said there's a fourth one, okay? Insurance premium. And he said there's about 10,000 units that were about to be going into production. They had to stop because nobody can build at this moment. And he said, my people needs to work, okay? And the way, the economy function, we have to put these people to work, and the way we put them to work is for development to go forward. So now you have a developer, right, that is not sitting on a project and would like to come forward with this development. These are the couple of projects that you definitely
30
want to
seconds.
approve for the city of North Miami. Secondly, most of you attended the North Miami budget meetings, both community meetings, there were 3 of them, and 2 budget meetings, okay? We received a total of $2 million total from the entire city additional taxes. This project will give you $2 million on an average of 20 years. Just one single project by the bay. So for this reason, I ask you to approve those variances, and the lawyer made it very clear to you that you do have the authority
Respectfully, that's your time,
and
sir.
the power to approve it. Thank you.
Thank you.
Before my time, you need to swear me in.
Yeah.
Thank you. Please stand and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in these proceedings?
I'll do. I'm Dr. Medina. Like my friend Andres said,
Address.
1270 Northeast 124th. I sat where you are. This is a very simple thing. They're trying to circumvent the height of the city. If they want a zoning change, they can ask for it and they can come and get it. 78% of increase is unheard of. This variance, this land, which I'm very familiar because I used to go there all the time, that used to be owned by Bill Pravatel, a good friend of mine. It's irrelevant. The important thing is that the citizens of San Souci rejected this plan on the Bermoshe community outreach. They rejected it soundingly. Everybody that lives here, but maybe the ugliest house here in San Souci, rejected it. So the question in front of you is that, are you going to follow the rules? We fought real hard to make sure that we don't exceed 115 feet on this BC. Real hard. We had to fight real hard not to get 1,000 feet, which is what the developers wanted. This is one of our finest neighborhoods, and the quality of life precedes, in my opinion, any benefit, that economic benefits. Also, take in consideration that one of the persons who testified, who was a young boy, but she looks like a lady to me. So they're reading from a script. So you need to take that into consideration. The residents that are going to be affected by this are the ones you have to listen to. And finally, it is up to you to keep the quality of life of this city. The traffic is getting outrageous, and more the quality of life. It is very important. Money is irrelevant if you are going to die at 60 of a heart attack, or you're going to have blood pressure, or you're going to have...
Respectfully, sir, that's your time.
Thank you. So please reject this. There is no other option.
Hold on. Anyone else? Okay. Were you sworn in? No. Okay. We'll swear him in and let him be the last one, and then I'll close public hearing.
Can you please, I know everyone. Can you please raise your right hand?
My right hand?
Yes, please. Do you swear to tell the truth, the whole truth, and nothing but the truth in these proceedings?
Yes, ma'am.
Okay, I'll start the time.
Good evening. My name is Dylan Lehman. I reside at 1855 Northeast 121st Street, and I am for this project mainly because I believe the millions of dollars bringing into the city, it's going to help a lot of better job opportunities, as well as new employment for new people trying to build a better life for themselves. And as well, the money flowing in and out of the city is going to help with competition in terms of competing and finances with neighboring cities such as Aventura, Sunny Isles, Surfside, North Miami Beach, along with the coast of Florida. Thank you.
Thank you. Public hearing is closed. Applicant would like to add something.
Absolutely. I had a reservation of time for rebuttal, so I just wanted to come back and address the rebuttal time. I will keep my comments very brief. With respect to some of the comments that were made, we've laid out what we believe demonstrates how we meet all 6 criteria of the code. It appears that your staff attorney has a different opinion, the staff has a different opinion, but that's what they are. They are opinions. And from our perspective, we think that the facts that we've demonstrated to you are items that meet and comply with your code. Now, I do think it's interesting. It's very interesting, the items that I've heard this evening, particularly from some of the residents within this area regarding having to go through a text amendment as opposed to a variance. Because I can tell you, as the attorney who represented the White House project, that we were told in that project not to seek the text amendment and to seek a variance. And in particularly, we were told that if we did anything on the south side of Northeast 123rd Street, that they wouldn't have an objection to the project. So I do think it's interesting that people are moving the goalposts with respect to their perspectives on the project, with respect to their perspective on the development, and with respect to what we're seeking to do. Again, what we've done and what we've laid out before you has to do with the irregular shape of the lot. We have identified by each criteria of your code how we comply. We have demonstrated, whether folks agree or disagree, how we are in compliance with each aspect of the code. Now, I'm going to say this. I know that there are different people who have a different perspective on this. As an applicant, applicants have the typical ability to rebut. Staff is supposed to be an impartial party to this. They're not supposed to come in and weigh and put their thumbs on the scales to tell you what you should or should not do. So on that note, I wanted to be very clear on that because I do think it's highly unusual to have that type of demonstration. However, that's what's proceeding and that's how it seems to be moving forward. With respect to this project, we believe that we've demonstrated how it meets the code, the irregular shape, and we've cited to case law with respect to it. And we think it should be approved. Thank you for your time, and I'm here to answer any questions that you may have. Thank you so much.
Thank you. Mr. Cook.
Through the chair, thank you, Madam Chair. Contrary to our honorable guest and applicant representative, Mr. Gassant, staff is here not to put their thumb on the scale, but only to illustrate and indicate facts about the case. What Mr. Hill brought forth about the irregular lot is a fact, not an opinion. That was based on court law and what transpired. And it was relevant to what the applicant said to give a perspective, not to put any kind of thumb on the scale. Again, the applicant spoke about some of the hardships that they stated, one of them being about how the industry has changed with the cost of materials, with insurance, with the interest rate. All of those are true and relevant in the aspect of building, but that does not cause for a variance. Financial hardship is not a cause for variance. That's just for the sake of fact. In principle, just as a perspective, if I may take a point of privilege, I spent 11 years in the city of Miami before I came here. And you know we're about building, and I was intimately involved there. We don't have an opposition to height. I don't have an opposition to height personally. I understand the benefits of it. But my job as a certified national planner is to present the facts and come before you with the best interest of the city as a whole. Not that I'm in opposition of what they want to do, but give them an idea on what mechanism that they should implement to do their change. Variance is not the process that you utilize for this. It is through a text amendment. Thank you.
Can I ask a question then?
Okay, I'll open for discussion. You may start, Ms. Modestine.
Mr. Cook, to your last point, if it's not that they should have sought a variance, but instead went the text amendment route, was that something that wasn't discussed, or?
The applicant came forth with the variance request, and I think Mr. Gassant gave you a perspective on what brought him to this point with other applications that he had went forward in the city and how that went forth. you know, it was not discussed, to answer your question correctly, Ms. Modestine. It came in as a variance, and we processed it as such.
Can we get a brief overview
wasn't
of what
done.
the process? Oh, I apologize. I'll go afterwards.
Thank you. And then this is sort of like a random question, but I think it'll answer, for me at least, the challenge with height, which seems to be the variance that's the more of an issue than the others. So SB 102, Senate Bill 102 was passed, and I know that speaks to, also known as the Live Local Act. I know that was passed sometime in the summer, and it speaks more to affordable housing or workforce development. But essentially, that bill would allow for height to be at whatever number.
Yes.
If it's specific to affordable units. And I know in this case, this is luxury, but height is height. So if we were establishing through a Senate bill that, you know, trying to increase the opportunity for more affordable units in the city, I get that. But then also, I kind of want to get some clarity on whether or not that type of situation would be a challenge in that area.
So the Senate Bill 102, Live Local Act, does allow the applicant, if you are seeking to do 40% of workforce or affordable housing, to get the highest height that is allowed in the city by right. And then you are operating either in industrial, commercial, or mixed-use zone.
Gotcha.
The highest height in our city by right is the BZ zone, which is 115 feet, which is what they'll be allotted.
Gotcha. And then we spoke about, sorry, just my last point. So Mallorca is at 169. Was that accurate?
Correct, for what we understand, yes, ma'am.
And then Bayview is at 189.
Yes.
Okay, that's all for me.
I just need a point of clarification, if I may, board member. The highest height in the city is not 115. It's Solomia, which is over 400 feet. So I just want to be clear about that's the highest height in the city. But I just want to be clear.
Again, for point of clarification, I know that that the applicant believes the height by right is BZ zone, which is 115. The height that Solomia has was created through a conditional use and a development plan to allow them to go up to 450 feet. 6 feet floors would not be counted towards that height. It'd be for the podium. That is through a development plan, not by right.
Yeah. Okay. I don't want to get into a detailed discussion about it, but that's just not Senate Bill 102. The Senate Bill allows you the highest height within the city, but I will leave that alone. I don't need to go in the back and forth with Mr. I will leave that alone.
When you had your presentation, you spoke to wanting the height to be a specific way because you wanted to address sea level rise or resiliency. Can you speak more to that?
Absolutely. So one of the things that we had to do as part of the development of our project and as part of this program is that anything that's developed along the shoreline actually has to go before the Shoreline Development Review Committee. As part of that, we have to elevate, we have to demonstrate the elevation with respect to the site. And as a matter of fact, the city's code has instituted a baseline to say that your base flood elevation plus one is your height, because the city wants to incentivize people to build higher for flood resiliency. So one of the things that happens is as you're building higher, you help to be able to take into account the flood resiliency of the site and be able to take into account the sea level rise that's occurring. So that's what we've been seeking to do as part of the project. So when we went before the Shoreline Development Review Committee, we talked about that, and we talked about some of the aspects of the site. I really can't, I'm not going into all the specifics of it because those are the issues that would come up at the detailed site plan level, but those are some of the issues that come into effect when we're talking about the height and taking it into account.
Mr. Shield.
Any more?
No.
Are you good? Okay.
Mr. Shield.
Certainly don't want to interrupt. A quick question for Mr. Cook, and then a few questions for Mr. Gassan after that. So the question I have, let's talk more about the text amendment. What is the process of that, and how is that different from an applicant coming before this committee for variance? And why would that be used?
So the text amendment is to, as you're saying, as amendment to the LDR code.
Mhm.
And that would require going before the planning commission for recommendation and ultimately go to city council for approval.
Okay. Is there a reason why?
And it has
I
two
thought-
readings at city council.
Okay. Is there a reason why that was not suggested for this particular project versus it coming before this board?
No particular reason, no, sir.
Okay. Go ahead, Mr. Hill.
It's not really something that has to be suggested. A person has, a property owner has a right to file an application for a variance.
Mhm.
But the, let's say, respect or consideration given to the adopted policy of the city council is that which is reflected in the land development regulations. And it's up to them primarily to decide whether the standards that they set should be raised in the absence of meeting variance criteria.
Mhm.
So the question here is, are the variance criteria met to justify overriding the policy that the city council has set? Staff recommendation is no. The case law that I've cited says no, and it's up to you to decide whether it should be permitted to override the city council policy that they set in the BC zoning district.
Okay. Understood. Understood.
Your next question.
Next question. So, to Ms. Monestein's point, I mean, this is really all about the height. Let's just be honest. Like, the other, we'll certainly talk about the other issues regarding the balconies and the pool, but this is really all about the height. So, to that point, a couple quick questions for you, Mr. Gasant. So, of the 203 feet and 10 inches, how much of that is elevation in or around sea level rise? Like, in order to elevate the building a little bit, obviously get it out of the floodplain, make sure that from an engineering and an environmental perspective, it's good. Like, how much of that height? Is it like a story? Is it 10 feet?
So to give you a perspective, if I may, on
Sure.
that, Mr. Shield, the code, as the applicant representative stated, is you have different flood zones rating. You have EV, you have most intense. I believe this is an EV, I'm not sure. And whatever that floodplain is, they designate that it could be 10 feet, it could be 20 feet, and then our code says +1.
Mhm.
And that area is not counted towards their height.
Okay.
Okay, that's not counted towards their height. So when we characterize it in a sense that, oh, we are doing this for floodplain, it's true, but it's not adverse towards your height, because your height doesn't start counting until +1. So if it's 10 feet is the floodplain that you need to be up, and then it's +1, then we start adding, say, from that point on, you can go up 115 feet.
Okay. Any addition to that?
So the addition to it is that it's about 5 or 6 feet from the base to go up.
Mhm.
The issue that we have is that we're also doing parking underground. So to be able to justify it based off of what we're seeing within the market with the amount of market rents and the, well, not the market rents, but the market prices, the construction, the insurance, in order to justify this type of development, which is the type of development that we think, and which is one of the criteria in the code.
Mhm.
One of the criteria in the code is to demonstrate that this is the least amount that you need in order to justify it. To justify this type of development, we have to go this high to substantiate the cost that's associated with us going down and building up. So that's, again, we have some varying opinions. The staff, the attorney seems to suggest that the case law doesn't support it. I've cited case law that I believe directly is on point and supports it. So from our viewpoint, because it's an irregularly shaped lot, because of the criterion in the city's code, we meet the criteria and therefore should be entitled to the approval. And that's really where we're coming from at this. Now, people have different perspectives on that, but our view is that once we demonstrate that, we should be entitled to an approval of it because of that.
Okay. Is there structured parking here, meaning some type of parking deck within the actual collateral?
Yeah, so all of the parking is actually underground.
Really?
The parking for this site is all underground, And the core reason why we're doing that is because we have to anticipate that we have to deal with the site design criteria of the city's code. And one of the things that the city does not want to see is parking at surface. So we wanted to be able to develop the type of development that would be luxurious and that would be able to accommodate the type of luxury residents that we think we're going to attract to the site. So the type of development that we have developed for this site is all underground parking.
How many floors are the mechanicals? It looked like in your design, like 2 stories, about 2.5?
Yeah, it's about 2.
Okay. Another question. Tell me about traffic. I want to know, I know that there was a traffic study that was provided. I want to know exactly what the impact, if you could just give me a summary, if it's not you or maybe somebody else from the applicant's team.
So I will give you a summary. I do have the traffic engineer, and he can correct me on this. So we did do a traffic study. That traffic study actually demonstrated that it's actually a net negative.
Okay.
And the reason why it's a net negative is because the type of trips that's created by a high-rise is substantially different from the type of trips that are created by a low-rise development.
Why is that?
So I'll have Richard Garcia come up and speak to some of those points with respect to the traffic.
Hi, good evening. Richard Garcia, 8065 Northwest 98th Street. That's correct. So what happens is high-rise units are typically probably more expensive, more luxurious, and so the type of socioeconomic people that live in high-rises generates less trips. In fact, when we do the trip generation and compare the existing traffic with the future traffic, even though it's growing in number of dwelling units from 27 to 90, it generates in the AM -7 trips. And in the PM, it generates -3. So and this is based on published data from the Institute of Transportation Engineer. And I was looking up earlier the number of studies. And for the AM traffic, it's based on 108 studies that ITE has. And for the PM, I believe it was around 90 studies. So in total, it's about 200 studies that this data is based on. And it's published data, like I said, from the Institute of Transportation Engineers.
So there's a correlation then between these being luxury condos and not having as much traffic impact, is essentially what you're saying.
Essentially, but it's really not listed as anything with the word luxury. It's just high rises.
High-rise,
So anything that exceeds 10 stories is the definition from ITE of a high rise. They generate much lower trips, and the rate for the trip generation based on all those studies shows that it generates a lot less traffic.
Okay.
Yep.
Thank you.
Thank
I have more questions.
Can we
But
see if
please,
Mr.
go ahead.
Mediamaid has, you have a question?
Well, I had a question, but he asked it.
Okay.
But I do have another question. You mentioned early on,
Speak
I'm
into the
sorry.
mic.
You mentioned early on in reference to doing some renovations in the park on the corner.
That's correct.
Can you tell us a little bit about what you're going to do there?
So what we've done is we've made a commitment to provide for $100,000 for the provision of funds for the Bill Lehman Park. That contribution is part of the shoreline development approval for the site. It is something that runs with the land for this redevelopment of the site. So assuming that the site is able to move forward to site plan after this variance, we have a commitment to provide that amount to the $100,000 to the city, which the city will then implement for utilizing to improve Lehman Park. What we anticipate is that it's going to provide for additional parking spaces, bike racks, and additional viewing of the bay. Because one of the aspects with respect to the redevelopment of the site that was important for the shoreline was that more people have access to go to the park to be able to enjoy the bay than currently has. So we wanted to make that commitment up front as part of this project.
Okay, thank you.
My pleasure.
Yes, could you tell what's the unit difference between the height of 208 and 115? How many units we talking about?
We're talking about like.
If I'm not mistaken, I don't want to answer for them, so please correct me if I'm wrong.
Mm-hmm.
But my understanding was that the current entitlement of 115 is, I think, about 78 units, and that with this additional height, hopefully brings them up to 95.
There's several different things that I want to address here. So one has to do with the feasibility of the site, of whether we could actually build it on this property at a lower story for a lower cost on the site, and at that height. As it stands today, the understanding that I've gotten from my client has always been that at 115 we cannot develop this project given the cost of the market. So what we need to do is to incentivize the type of views that will command the type of pricing that's going to be commensurate with the cost of construction, that's going to be commensurate with the rise in insurance, and that's going to be commensurate with the rise in interest rates. So there may not be, from a density count, a difference, but the price difference of what we could sell those at and what we could actually make on the site makes it infeasible to develop that site. Now, the reason why I'm making that point, again, goes back to the variance criteria, because I think that there's a misunderstanding. There's definitely a misunderstanding and certainly a miscommunication between the way the staff is looking at this and the way that we're looking at this. The code provides that the variance that you're seeking has to be the least to allow the reasonable use of the site. Based off the market conditions that we're in, the least variance that we can seek for this site is this height. To make it justifiable given the cost of construction, to make it justifiable given the cost of interest rates, to make it justifiable given the rise of insurance. So that's where we are with respect to this project. So for us,
I'm sorry. In that sense, I don't think with the resident that came, I don't think you're selling them. It should be, I think your point should be, is your parcel in such a way, will it allow you to reasonably build? That's what and it goes back to, if we're talking about, is it the cost of building and all that, I don't think that's helping your case here.
Well, Chairwoman, we may just have to agree to disagree on that point, because I think under the code, under that criterion of the code, it specifically says that the variance that you're seeking is the least amount of variance that you need to make reasonable use of the site. And the only way that we can make reasonable use of the site is to be able to obtain a profit that makes sense. So I understand your concern. I just respectfully disagree with the perspective that you're taking on it. So back to your point, Board Member Monazir, the reason why we believe that we need this height is because it's the least amount of variance that we need in order to make this project work.
I heard earlier, like 2 months ago, there was a community meeting, but it sounded as if it didn't go too well. Were there any concessions, any meeting of the minds, maybe on one or two particular matters?
So that's a very good question. One of the things that happened is that we had a robust community meeting. And as part of that meeting, one of the things that I always do, and one of the things that we always try to do, is find points of compromise, find opportunities to discuss. And what we were told consistently at that meeting is that there's nothing, Mr. Gassant, that you can tell us, there's nothing that you could say that would be able to demonstrate that we would want to agree with. We don't think that you should be able to be entitled to anything. So that's why I'm not here before you with a compromise, because I was told point blank, it doesn't matter what you say to us. It doesn't matter what you tell us. We're not negotiating with you on this. You shouldn't bring this before us.
My question was in the garage, but he mentioned it earlier. The garage being down on the ground level, the bottom level, underground.
Underground,
actually,
that's correct.
Underground. Okay.
If I could just
And I don't
quickly
want to
follow
miss,
up on that. Go ahead.
because Ms. Pierre-Louis is sitting down there, and I keep looking,
Of course.
and I don't want to miss you. Go ahead.
I'll keep my comments brief. Because I live down the street, I'm somewhat biased on both sides. I can see pros and cons, but I think ultimately it comes down to there being some level of balance. There are codes for a reason. We understand that there has to be a financially viable enterprise for a developer to proceed with a project. However, it seems like we have opposite extremes in this particular case as it relates to the height. And in hearing the dialogue regarding the alternative process, the amendment, I sort of question why this was undertaken in this particular process versus the other. But that's not for us to make an assertion. That was whatever it was. So honestly, I'm sort of torn on how to go with this. But I've heard both sides. I'm listening. I understand from one perspective there are financial benefits not only to the developer but also to the city. But living down the street, I know that it's going to be quite an undertaking and also quite a disruption in many respects. And it's going to change the dynamic of the neighborhood. Whether that's good or bad, that's to be determined.
Mr. Evans had a follow-up.
Who had a follow-up? Oh, Mr.
I did.
Held.
So
I remember you did.
it was a
but-
follow-up to your question.
I'm sorry?
You can go first.
Okay.
So just to kind of tease out a little bit, in that community meeting, there were concerns brought up. I guess the question is, how are you as a team addressing those concerns to make sure that folks can sleep at night and the community eventually support this project?
So, as you know, board member, we're at the very beginning of this process. And as part of this process, the overall process, both the BOA and then subsequently before the city council, there will be a process for a site plan approval and potentially a CUP. As part of
What
those,
is CUP?
That's a conditional use permit.
I know what it is,
Yeah.
but I for the people. I've been doing real estate for 10 years. I'm asking these questions so that everybody else here and watching can know, like, what's going on. Please,
Absolutely. So the CUP is an additional process for the development of this project. Those items, as you know, are not before you, and typically what we do on these projects is that we engage in a community benefits package to discuss with the community, to engage in those community benefits package, and then we also bring those community benefit package before the city council. And we talk to the city council to ensure that what the city believes that it may or may not need for the site or for the area is being addressed for the project. So one of the things that we made clear both at the meeting, one of the things that I've made clear every day since that meeting has been that we are going to enter into a community benefits package that looks to provide additional benefits for not just this area, but the surrounding community nearby. So one of the things that we are going to engage in, and one of the representations that my client has authorized me to make from the very beginning, is that we recognize that there is going to be a need for a community benefits package, that we are going to provide a community benefits package, but this is the very first stage. So because we still have to go before the city council, because the city council still has to make the decision on the site plan, it would make more sense for us to engage in that process of defining and delineating each of those community benefit packages with respect to what's going to be required before the city council, because the city council is the one that's going to make the decision and what's going to be before them. So that's one of the things that's going to end up happening as part of this project is going to be the community benefit package, but that's later down the road.
Okay, thank you.
My pleasure.
I have two final questions.
Yes.
I've asked you a lot.
No, that's
thank
my
you.
pleasure.
Let's talk the economics of this. How much is it to build this thing?
So I think it's over, and thank you, Andre, with the specifics. So the construction cost of this project today is already anticipated to be over $92.8 million for the site.
Wow. How much of that is
And soft costs? And soft costs of about $41.7 million.
Okay. How much of that is like just paying the bank for the loan and insurance and taxes and stuff like that?
Yeah, I don't know if those numbers are even specifically.
I'm going to assume it's a lot, but I just,
it is a
just
lot.
asking for the public to know. General.
It's a lot.
Okay. Let's assume this thing gets built.
Mr. Held is waiting. Go ahead.
And I'm going to stop on this question. This is my last one. I love the economic impact slides. They're great because then they get you excited. You're like, oh, wow, $18 million in 10 years? The honest question for the public, like, how do you actually tabulate that? How do you calculate that? What is that economic impact? Is that tax revenue we're receiving as a city? Is that the actual employment of contractors and subcontractors, employees who are going to live here? How exactly are you getting to those figures that you showed in the presentation?
So those are actually tax revenues that are generated from this
It's just
specific
strictly
project.
tax revenues.
Tax revenues, and it's strictly tax revenues that's going directly to the city. So
Okay.
the numbers that I referenced regarding the 1.7 within the first year, and then over 18 million over 10 years, 43 million over 20 years, that's all taxes. That's just going directly to the city.
Okay.
The total tax is much more, it's much higher.
Okay.
Mr. Held, I know you've been waiting. I'm sorry.
Just.
I'm done.
sorry.
I promise.
Thank you.
So, I just want to deal with the issue of the economic return and reasonable return. So the case law in Florida is clear that economic hardship is not a sufficient criteria for granting of a variance. And one case in which that's stated is Metropolitan-Dade County versus Betancourt, also Florida 3rd DCA, 1990. And I'll read from it. It should also be noted that reasonable return, as used in the context of citing a case, but Florida zoning law does not mean in the context of a residential area that an economic return must be produced. Instead, the inquiry is whether there are uses which are beneficial to the owner and consistent with the residential zoning.
Thank you. Okay. I heard, I've allowed all my colleagues here to speak, and with me, I don't have a real estate background and I don't have planning background. I'm probably the most average Jane on this board and have been on this board for a long time. It's written in the sand, I guess. And I'm saying that you've got a property that's near on the bay. But development is coming. And we see high buildings being built all over in our city, not just our city, but everywhere else. So in North Miami, I know it's coming. I just want developers, your clients, he owned the property, what have you, they're coming into a community, and it does not help when you're alienating, you know, from the onset, everyone that's there. Because I would have preferred that at that meeting that was held at Betmosh, that some kind of understanding, a give and take on some part, because I heard a bunch of people come here, but they're not gonna be impacted by that building that's going up. And I do understand the residents, okay, because they're gonna be the one to live with it, but at the same time, I do want them to understand that development is coming. My community where I live may be the next one, but with them, you've got that nice area with the water. That's where it's coming first, because people want to see what's up there. They want to see that water view. So I guess I just want, I would have liked to see a bit much more give and take on your part. Well, you know, I'm saying your part because you represent the client, and listen and understand where they're coming from, and maybe some concession, because you're talking about from 115 to 203, you know, that is quite a bit, you know, but we do get it, because you drive off to North Miami Beach, you know, as soon as you hit Biscayne and 167th, 163rd, is it there? Or is it 167, 163rd? I mean, you're seeing it, okay? That's where people want to live. I get that. But at the same time, I don't want our resident to feel that, you know, they don't matter. So that you could at least listen and see how we can come to a happy medium. That's all I have to say. Okay, well, and we have to vote on each one of these separately. Let me remind you guys. We discussed them once, but we vote on them separately. Jennifer, do you have your hand up?
So you can take them in the order that they are in the agenda.
I
If you want
guess
to.
so.
Okay, Madam Chair?
So V-09-23, which is variance to allow for the balcony encroachment.
I'd like to make a motion to approve that.
Okay, move
Now second.
and seconded by Mr. Mondesir. We'll do a roll call.
Mhm.
Sorry about that. Board Member Montesir,
Yes.
Board Member Montetin?
Monestime, Monestime, Monestime.
Yes.
Board Member Shields,
Yes.
Board Member Pierre Lewis,
Yes.
Vice Chair McDermott,
Yes.
Vice Chair Felipe.
but
Chair, I'm sorry.
It's okay. Don't care. Yes.
The motion passes.
Now, V-10-23.
Move to approve.
Second.
Okay, 2 seconds. All
So
right.
to clarify, this is the
This
setback
is
for
a
the swimming
pool,
pool.
the swimming pool.
Board Member Montesir,
Yes.
Board Member Montes, oh.
Monestine.
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 Yes.
Yes, Monestine. I'll get it right. Board Member Shields,
Yes.
Board Member Pierre Lewis,
Yes.
Vice Chair McDermott,
Yes.
and Chair Felipe.
Yes.
The motion carries, and it's approved.
All right. V-11-23, and that's the maximum height of 115 in the BZ zoning district.
All right. Board member, oh,
No,
I'm
they need a
sorry.
motion.
I'm sorry.
You need a motion.
Motion.
I need a second.
Second.
What is the motion?
To approve.
To approve.
Point of clarification, each of these motions to approve are made based off of staff recommendations, correct?
Yes, thank you for clarifying.
Meaning with all the conditions?
With all the conditions, yes.
Yes, with all the conditions.
All right. Board Member Montesir,
Yes.
Board Member Mon Estine,
Yes, thank you.
you're welcome. Board Member Shields,
Yes.
Board Member Pierre Lewis,
No.
Vice Chair McDermott,
Yes.
and Chair Felipe.
On that, I also vote no, but it passed.
It passed. This motion does pass.
Thank you, Chairwoman. Thank you, members of the board.
Madam Chair, may I make a quick comment on this?
Yes.
Woo-wee. Listen, I think that this is probably one of the most important types of conversations we have as a city. I mean, to be clear, the White House Inn project, I personally was not for that. It was an awkward site in particular, and it also put us at risk with the Harbor Islands, and there was a lot of other issues in the community as well that are very valid here as well. Extremely valid. My point is this: I think that there are a number of steps that this project still has to go through that are extremely important after this, right? Which is conditional use permitting, site planning review. I think especially given the economic impact that this could have, which I think is great, but the community benefits package is the most important thing, and that it's made sure that this project represents any type of offset of impact, and also just helping continue to beautify our part. I say our part of the city because I live on this side of North Miami, not too far from Sans Souci. But I think the other thing that head and heart here, like part of my heart too, is that I want North Miami to thrive. Like, we deserve nice things, like Aventura, like North Miami Beach, like the city of Miami. There has to be a balance of it, though, you know, and to that point, though I support it on the head of the argument and the actual points, the 6 points of whether or not, the 6 criteria that are mentioned in our code of whether or not we should approve a particular variance, there's also still a lot of work that needs to be done here in making sure that in these 6 other steps that this development has to take, that the community is a part of it, and that our council,
And
you know, make sure that they make a decision that represents all of us and
I
what's
wholly
needed.
agree with you, because with these changes, similar to what I said, because I've been on this board a long time, it was an issue way back with building in terms of doing the docks and all that, and we knew changes had to be done. So they actually had staff and the planning board and all these people were involved, and changes were made. Now it's coming. I don't want the residents in that area to think that we completely dismiss them, but they also have to be realistic and know this is what's coming. So back then, you wanted it to stay that way, but at that time it made sense, but now let's look at what's coming and what can, how can we better do this? And really, maybe they can move, decide and say, okay, 115 is no longer the reasonable thing, let's go up a little higher, and then they could decide, because they still live there. Because ultimately what's gonna happen, people are just gonna sell their homes. And then when that happens, more developers are gonna come in, because they're not coming in to get the family homes.
Right.
That property, that area, they want high density. They want that beautiful, you know.
And
at
to
least-
that point, you know, final thing, our city deserves and needs smart development, and I think that that's been the refrain that we've been talking about quite a bit in the last couple of years. But the other thing that I don't want is for us to, and this is for the applicant, of course, for us to help usher this along on the other 5 steps that 5-6 steps that needs to go, and then it not happen, because a whole lot went into the White House Inn and then it's not here, right? And development didn't happen, and we didn't get the economic benefits that our city deserves. And I think it's a balance of it, and to that point, I'd like to see this continue to hopefully, you know, match what our community needs and also what our city needs.
Yeah, and I think that the community benefits portion is extremely important. There needs to be something left on the table when the developers leave town.
Absolutely agreed.
Okay. With that being said, let's continue with our agenda. Any old business to discuss? New business, beside Ms. Watson joining us? New business? Motion to adjourn?
So moved.
Second.
All in favor?
Aye.
Aye.
There you go.